बिस्मिल्लाहिर्रहमानिर्रहीम। सदर मोहतरम जनाब उमरी साहब, सदर मोहतरम ये हमारे जलसे के जस्टिस अहमदी साहब, द फॉर्मर चीफ जस्टिस ऑफ इंडिया, the other dignitaries and the academicians and the scholars present on the dais, and respected ladies and gentlemen, I take your permission to address this gathering in English, though I may at times relapse into saying something in my Bombaya Urdu also. सबसे पहले तो मैं आप सबको मुबारकबादी पेश करना चाहता हूँ कि आपने इस मौजू पर ये एक सिंपोजियम रखा है। ह्यूमन राइट्स, इंसानी हकूक़ के लिए बात करने के लिए जमात इस्लाम हिंद के दिल में अल्लाह ने दर्द भी पैदा किया है और इंसानी हकूक़ को अमल में लाने के लिए एक दीवानगी भी पैदा की है। मैंने देखा है गुजरात के फसादात के बाद जो जमात उलमा हिंद ने जमात ने जो कारकिर्दी की है वहाँ पर गुजरात में, और वहाँ पर जिस तरह से उन्होंने जद्दोजहद की है उसका मैं खुद एक गवाह हूँ। इसलिए मैंने सोचा कि जो कतिल सिपाही ने एक शेर कहा है कि फिर चाहे मुझे दीवाना कर दे या अल्लाह, दिल में मेरे दर्द दे या अल्लाह। तो जमात के दिल में दर्द भी है और दीवानगी भी है, और यहाँ पर जो सोशल एक्टिविस्ट जमा हुए हैं उनकी दीवानगी को देखते हुए कभी ये भी महसूस होता है कि उनकी दीवानगी को देखते कोई दीवाना भी कह दे कि दीवाना है ये वो। तो इस मौजू पे जो आप लोगों ने लिखा है, इसलिए इसका मुस्तहिक है जमात कि इसी बात पे ज्यादा गौर करे और गौर फिक्र करे। हमें ये बात समझनी है कि ह्यूमन राइट्स क्या है, व्हाट इज ह्यूमन राइट्स, और उसके पीछे क्या फलसफा है, एंड व्हाट इज द फिलॉसफी ऑफ द ह्यूमन राइट्स। अक्सर ये माना जाता है दैट ह्यूमन राइट्स वर ओरिजिनेटेड फ्रॉम द वेस्ट, बट वी फॉरगेट दैट Islam is also taken the lead in pronouncing the human rights through Al-Quran. और आज जितने भी ह्यूमन राइट्स यूनाइटेड नेशंस डिक्लेरेशन ऑफ ह्यूमन राइट्स के चार्टर में लिखे गए हैं, वो सब के सब हमारे वहाँ अपनी किताबों में मौजूद रहे हैं। जैसे कि मैं से कबल प्रोफेसर वानी ने कहा that he said, and he laid emphasis that the seeds of the thought have always been laid in the literature of Islam, in the philosophy of Islam, and in the juristic writings of Islam. But Maulana Maududi, when he wrote a letter, wrote an article or a treatise on human right and Islam, he objected to certain basic approach that the Western world has towards the human right and Islam has towards the human rights. The basic difference according to Maulana Maududi is that in the human right approach of the West, there is emphasis on individualism while there is hardly any mention of the obligations of an individual to the society or the community. In Islam, we have got the just balance, adl, between the competing interest of an individual and the societal interest. Because adl is itself is a part of the human right jurisprudence. Bar and very frequently, Quran emphasizes that we must create a social order which maintains the just balance. Just balance, adl, is the basic philosophy of Al-Quran. और यहाँ पर हमने देखा है कि जब भी इस्लाम में जब कुछ भी किया गया तो every right is to be read in the context of the obligation it correspondingly creates. And in दोनों के बीच में तवाज़ुन रखना, balance रखना is the challenge of the Muslim jurists, Muslim intellectuals, Muslim lawmakers and the Muslim social activists also. So ये हमें तवाज़ुन रखना, ये बैलेंस रखना, ये हमारे लिए एक बहुत बड़ी जिम्मेदारी है और ये जिम्मेदारी को हमने बखूबी और हमें निभानी है. Now you cannot establish a social order in which the individual can have his full freedom. Individual without freedom can establish no social order, and any social order which is established which denies individual freedom becomes oppressive. So this just balance between the two is the underlining philosophy of the Islam and the human rights jurisprudence in Islam. Now, if we look at the Western world, we are told that the beginning of the thinking on the human right began in 1257, when an incident of preparing the Magna Carta during the time of King John at Redmond took place, and the first charter of human right was given to the king. That was followed by other legislations, that the Petition of Rights, which was presented in 1628 and again followed by the Habeas Corpus Act of 1679. I will not take you into the details of all those provisions and all, because this is not an academic gathering. This is the gathering of the social activists. What I want to emphasize is here that though in terms the equality was given, the right against the rulers were given, were they really implemented? Was there really a gender equality in United Kingdom, in Britain from 1297 onwards? Because it is a recorded history that the women had no right or the proprietary rights in England, in United Kingdom till 1925. So for about 400 or about 800 years, they merely remained satisfied with the platitudes contained in this declaration, in these documents, in these instruments. But those documents never been implemented, and that were in 1925 for the first time the women were given the right of property, while Islam conceded or gave that right to property as soon as the Quran was revealed. Then we come to another rather milestone in the development of human rights from the Western point of view is the American Declaration of Independence, and that took place in 1776. And it said that we hold these trust to be self-evident that all men are created equal and they are endowed by the Creator with certain inalienable rights. Mind the year 1776. All men are equal and they are endowed with certain inalienable rights. In spite of this declaration, slavery continued in the United States. And the blacks who were bought as slaves were considered a chattel or the property of his master. Even so much so that in 1840 and 50s, in the decade between 1840 and 1850, a case took place in United States and we reached up to the portals of the United States Supreme Court, and it said that the slaves have no right. And that is the pronouncement of the highest, the apex judiciary of the United States. So you had the declarations, but you had never created a climate for implementing those declarations. At every stages of the society, it was in denial only. The slavery was abolished not by any judicial reforms, not by any social reforms, but by the clash of arms. And those clash of arms took place in the form of the Civil War in the United States. And you know all the history and which Abraham Lincoln fought for it and ultimately got the slavery abolished. So the pronouncement of the human rights in charters is not the guarantee that it will be implemented or that it will be enforced in a meaningful way so that there is a real equality in life. That is the history in the United States also. French also then made their own declarations during the French Revolution in 1789, and then I take fast forward, we come to 1948, 19 December 1948, when United Nations declared the United Nations Declaration of Human Rights, and which was the first comprehensive human rights instrument, and which contained many individual rights, social rights, economic rights, and the political rights. And this document of United Nations Declaration of Human Rights was followed by further two covenants. It is the International Covenant for the Civil and Political Rights in 1967 and International Covenants for Socio-Economic and Cultural Rights. Our country has signed and ratified all these covenants. And all these covenants and the rights enshrined in these three instruments are enforceable in our country. They are the part and parcel of the part 3 of the Constitution, which speaks of fundamental rights. And those fundamental rights also contain socio-economic rights read with the directives, principles of the state policy. Now if we go into the details as to how these things happen, it will take a lot of time to say so. Even if to say so in a short manner, so it will be very difficult to condense it in a short lecture, a short address that I am making before you. But the Supreme Court took also a very, very progressive attitude and has expanded the definition of a life and liberty and has read certain rights in conjunction with the directive states of state policy and has conceded and has said that there are so many rights which are within the purview of the part 3, the fundamental rights of our Constitution. Like the right to work is now recognized as a fundamental right. Right of a patient to get immediate treatment the moment he is injured on the road is also a fundamental right. Right to shelter Now that is the ground on which I would like to address, and I would like to say that the social activists owe a certain responsibility to sensitize itself on this right of shelter. It is unfortunate that now in our country, when judiciary is very frequently passing the orders for the demolition of the slums on the ground of the orderly development of the cities. Here, if a person has come to a city and lived in a hutment and a squalid conditions, dirty and filthy conditions of the slum area, he has a settled possession over there. It has happened in a place like Bombay, that certain uninhabitable lands have been made habitable by these people. They have reclaimed certain things from the sea and developed their shanties over there. And now you are passing orders day in and day out, they demolish, you have no title to the land, you are encroachers. So therefore, what happens is this, that the right to shelter is a very important right, and let us not forget that people who seek shelter in the city are internal refugees or internally displaced persons. They have come to the cities not out of their volition, but under the compelling circumstances, socio-economic, and at times they are forcibly thrown out because of the undertakings of the construction of big dams and hydraulic plants and all that. So therefore, once you have the settled possession of an individual, then you cannot disturb that possession unless by providing compensation or alternate accommodation to the person who is in settled possession of the land. These are the issues, and then I think I wanted to speak a little on the manner in which the question of the equality of rights and the protection of equal protection of law is denied in our country, particularly in the cases where the group violence, not group violence, but the group violence takes place, and where there is a state complicity, either direct or indirect. There is a direct complicity of the state where the police, entire instrumentality of the state gets involved with the aggressor group and puts the marginalized section of the group by indulging into the police brutality, police violence, then also the unjustified encounters, and also by indulging into unjustified firing. Now on these issues, the society, civil society has to sensitize itself. Our experience is that whenever such incidents takes place, the group violence and all that, barring few exceptions like Jamaat Islam and Hind, Jamiatul Ulama Hind, they come forward and take up the pleas of the people who have suffered during these incidents. But general society, and particularly the elites amongst the society, remain totally indifferent towards it and try to keep away from all these things. If the society at large feels that the system is not merely not working for it, but it works in a manner hostile towards them, then the society cannot get involved into the national mainstream, because he doesn't get anything out of this mainstream. On the contrary, he sees the society, the system, totally hostile towards him. So it is very necessary from sociological point of view also that our society must get itself very much involved in the issue of protecting the human rights of the people who have suffered at the hands of the state complicity in the instances of the group violence. That is extremely important, and the previous speaker spoke about the fraternity, and he said that let there be a law relating to fraternity. Forgive me for saying that, but the fraternity is said that you can fight for equality, you can fight for justice, you can't fight for equality or fraternity. Fraternity has to be developed, and you have to create the cultural ethos to develop that fraternity, which is sadly absent in our country, and a fraternity is totally and absolutely absent from our political scene also. With these words, I conclude my speech because there are other speakers still to follow. Thank you.